Good morning.
Morning, everyone.
This is Cannabis Legal Group. I'm Travis Copenhaver.
Nicholas Galendez.
We're going to talk this morning a little bit about marijuana news in Michigan here. So we had a MMLB board meeting yesterday. It's probably going to be the heart of what we're going to be talking about today. Go over a couple quick things in the beginning, and if anyone's watching, we're happy to answer and respond to some comments and questions. So we're going to get right into it because I think we're going to have a lot to talk about. First, just an interesting tidbit. The city of Pontiac passed through a ballot initiative an opt-in ordinance for medical marijuana facilities, which was kind of interesting. You want to talk about that?
Yeah, so there were 3 ballots actually on the proposals for the primary elections. The first one was allowing 20 provisioning centers and unlimited grow licenses. The second one only allowed 4 provisioning centers, and I think it limited the number of growers. And then the third one was actually whether or not the city would opt out. So they put those 3 on the ballot.
Yeah, it was interesting, right? Because they had all 3 being voted, and it was kind of a which one's going to win kind of deal.
Yeah, under state law, basically, if there's a proposal and there's multiple ones on the same topic, the one that gets the most votes in its favor ends up passing and ends up being voted in as law. So,
yeah, and these were all very close. I think there were of the 3, the one that was probably the most favorable to the industry did end up passing, but it was very close, right?
Yeah, I was watching the election results, as it came, as they came in, and kept watching it as more precincts were reporting, and saw that it was pretty close. I think I sent you kind of an email just checking in on the thing before all of them had put the results in, but at the end there was about 9 votes that made the difference between the one that passed. So it's very, very close. I think the people have spoken, and it'll be exciting to see what Pontiac comes up with in terms of the application process and how things pan out there.
Yeah, and it definitely shows the power of your vote as well. Then what was the separation? You remember? It was just like
not 9 people for that one that passed, and so obviously people might have been sitting on the couch, decided not to go out and vote, or maybe be regretting it. You never know. I think your vote's powerful, and exercise your vote's always the best idea. So come November, it'll be the same issue for multiple array of issues and people looking to get into office. So.
Yeah, definitely. And it's interesting because, 10 people could have made that outcome be completely different. So, congratulations to the city of Pontiac. We look forward to seeing how that municipality designs its regulations and ordinances to accommodate applicants. And we'll be paying attention to that and maybe have some updates for you over the next few weeks. But we'll get right into it. Now, we do have some questions. We'll get to those in a moment. So we had another board meeting, the Bureau of Medical Marijuana Regulation, and the board met to give us updates about how that process is going and to discuss several pending applications. Just off the top, I'll kind of give a quick summary that Director Brisboe provided to the industry about, what the applications are looking like. They have about 637 paid applications for the state. That's up about 43 from the last meeting. So that's people who have submitted applications and paid the $6,000 filing fee for it. And of that, we see some new numbers for the different types of licenses, and there's some shifting around. Notably, if they break it down by grower, processor, provisioning center, etc., you're seeing numbers that are, higher than 43. For example, last meeting there was 101 people in the grower category. Now there's 152. So what's happening probably is a lot of applications are either declaring additional licenses that those operators might be pursuing, or maybe they never declared what kind of license they were seeking in the first place, just focusing on step 1. So we're seeing some of the ones that are in this process maybe kind of getting a little more clear on which direction that operation group is going to go when it's pursuing a license. That being said, we only have 50 more since the last meeting. So putting these applications together and pursuing these projects is still in its infancy here in Michigan. So if you're in the group of, I want to do this, but my application isn't in yet, obviously we're seeing, a slow rollout of this and some bottlenecking at the state for various reasons. But don't feel like you're behind. I mean, there's still ample opportunity to pursue one of these projects and get a team put together and get your step 1s in and start looking for locations.
And I think too, and maybe this is jumping ahead a little bit, but I think that a lot of the operators who had previously gotten their full approvals are waiting a little bit to pay their regulatory assessment fee, just to make sure, and again, kind of jumping a little bit more forward too, there was a testing lab that was finally approved. So now there's, 5 full license types. I guess you could argue there's somewhat of a skeleton of an industry now. So it's still very early, and a lot of those who even have had step 2 approval, aren't really up and running yet. So it's definitely not too late to get in to the industry, and I think the board and the department are going to finally kind of be freed of some backlogs that they've been experiencing, especially coming up after this next month and then the September 15th deadline.
Right.
So we'll definitely see, I think, a little bit more movement on the applications going forward.
Yeah, definitely. And I think it's been very emphasized by Laura directly, and then some comments made by the board, that just because people have applications in does not mean those applications are complete and ready to be discussed. I mean, and you see a lot of the denials we'll be going into are accuracy problems. So just having an application in doesn't mean that's putting you in a better position than someone who hasn't submitted it yet if your application's missing a lot of things. And it's quite frankly would have been easy to not realize you were missing items, because over the last several months this board's been meeting, it's been emphasizing the types of information it needs, as have Laura and as they've been reviewing these applications. But we're going to get right into it and talk about a few of the discussions the board had, and maybe glean some insight as to what you should be doing if you're in this process, or what the types of things Laura is looking at to make sure that these operators are going to be responsible contributors to the industry. So regardless of what your interest is in it, this is the industry as it's starting. And again, I'll emphasize this is brand new for Michigan. Regardless of our thoughts on it, just as every other state implements a program like this, it's going to take time. It's never going to go as fast as we want, and they're going to kind of have to figure it out as they go. Mm-hmm. I have my personal criticisms. I think a lot of people do. And, there's great reasons to be frustrated. I'm not denying that. But, at the same time, on the other hand, just keep in mind that, this board is the first board to ever do this in Michigan. And, they're going to make decisions we're not going to agree with. But at least, until things change, this is the scenario we have to, participate in. So it's good to know what needs to happen, even if we don't like some of those things. So yeah, let's talk about a few. We're going to kind of focus on denials and the reasons applications were denied. Some of this is going to be similar to previous discussions the board had, and we'll just kind of highlight a few of these applicants and maybe help provide some insight as to ways that might have been avoided or caution if you're pursuing one of these. So let's start with Harbor Farms North. Go ahead and kind of describe.
Well, I was going to say too, before we jump into that, just wanted to give an overview of the step ones and step twos that were before the board. There were 15 total step ones and 10 total step twos. Just kind of some overall takeaways, just kind of after having watched the meetings, I try to watch every single one of them just to get some intel on what the board discusses, kind of important, relevant topics that might fail or allow an application to be approved. I think some overall takeaways, just one, I know we had a concern in the past about confidentiality and privacy of certain applicants. Board members, as we had mentioned, this is new to them. So, I don't think they were intentionally trying to do it, but they were just having a discussion amongst themselves. But they were naming people by their full names. And I think, obviously there are some privacy concerns when you're talking about sensitive information like criminal history or financials. Finally, I think, they started referring to them by their initials, which I think is definitely can give some people some peace of mind as far as, will this get out there?
Right.
It's in the law allowing it. You have to be confidential, and
it's unfortunate it took so many meetings to get there, but it's great to see that that's finally been implemented. I think that the type of conversations that have to be discussed in step one are, quite frankly, not things that they should be identifying people in. If there's problems there, that should be handled without necessarily airing it out to the watching public. So it's great to see they're moving in that direction.
And then I think the second thing, obviously, there's disclosures and financial things that we'll get more into soon. But it's definitely there's a big importance on assumptions versus what's in the record. And obviously, the board is confined to making decisions based on what's in the record. And so whenever you respond to something, whatever you can put in your application, you want to make sure that it potentially addresses any assumptions that any board members might be able to make. And that if that includes, adding more context than you think is necessary, providing information, and we've said it before, if you have to have a discussion about if it should be included, you might as well just include it because, more is better, and you can never be more safe than sorry. So
right. And John, we'll respond to your question here real quick. We had a whole video on what the process would be if you were an applicant and you got a denial. There's an appeals process. It goes into the same administrative rules that you'd have in any regulatory body. If you wanted to appeal a decision, goes to an administrative law judge. And then if that, doesn't, that would go back to the board, and then they would have another opportunity to make a decision as a board. And ultimately, if those decisions you believe are appealable, they can eventually end up in court. When it comes to a specific board member doing something he or she, is not able to do, that would become, dependent on the circumstances involved, and it's probably not appropriate to go into because it take basically the length of the minute to describe. But maybe we can look into that for future conversation topics.
Mm-hmm.
But yeah, let's talk about some specifics though. So, like I mentioned, Harbor Farms North was one we'd like to mention a few things on. And this is kind of just re-emphasizing some of the information we already know. So what's going on with them?
Oh yeah, so for them, and the board also is a little bit better with Robert's Rules of Procedure. They're definitely getting their motions down. They're explaining their reasons for the denial on the record. So this one was knowingly providing false information and the moral character integrity reasons that we've heard multiple times.
Which again, just keep in mind that's what it's getting labeled as, but that's the legal reasoning the board has to base its denial upon. So what was actually done here might not sound that that egregious, but that is the bucket of reasoning that the board has to base its denial on.
Yeah, and so I mean this one objectively, there was an arrest involving delivery of marijuana. They gave the applicant 2 times to correct the deficiency and the failure to disclose, and it was a little bit unclear, and this isn't a direct quote from that applicant, but it seemed like they asked them to answer, and the second time they just kind of brushed it off and said no. And
right.
Whether or not that's actually the case, I guess isn't the point. It's more that when Laura does ask you questions, don't be adversarial. It's really important to be
right.
Helpful.
And to that applicant's credit, we don't know when those questions are being asked. Like we're not as the public privy to that. So obviously, if you'd watched the last 3 or 4 board meetings, you'd know that that's a big no-no, right? If you give them an answer they're not satisfied with, the board's going to lean into that. But if you filed your application back in December or January, before we had the insight as to how Laura and how the board is going to be dealing with these applications, it might have been reasonable to not put a lot of stock into those questioning, especially if it was a list of other questions to respond to. So, part of being the vanguard or some of the first applicants going through this is you're testing the waters. You're kind of going into the unknown, and unfortunately, we now know that if Laura asks you a question like that, you better provide a sufficient answer or at least reasoning for why you can't, and a no isn't going to suffice.
Mm-hmm.
So,
yeah, and
nothing against the applicant directly.
Mm-hmm.
We're just using this as a teaching experience.
Yeah, and I think too, from our side of things, we're assisting our clients and getting that information from them, but we always urge them to review it and be active in the process. Because obviously, we're not, the way we view it, we're not preparing the application for you or, all these consultants and other attorneys and other specialists doing it. We're helping you, assist you in identifying things that should be on the application. But it's really you need to take ownership over what's in the application and double and triple check what we even include in there and make sure it's accurate. Because, we don't know your personal history 100%. When you tell us things, we do the best to our ability to get those records, so on and so forth. But I think it's definitely, everyone should double and triple check their applications, especially at the beginning,
right.
Based on how the applications are treated and disclosures and deficiencies.
It's become abundantly apparent that accuracy is very important in this process. And, take that for what it is. Everyone's history is going to be different. Everyone has different financial information, criminal history, other disclosure information. And if, things are missing and that becomes known to Laura or the board, you either need to supplement the missing information or provide a reasonable answer as to why you can't find that information or why that information wasn't disclosed. Let's talk about a few of the other ones. The next one that I'd like to talk about is Green Labs. That one was interesting because we had an abstention, we had 1 yes, and then it was denied, but it was a 3-1, with 1 abstention.
Mm-hmm.
So what was going on with that application?
Oh, and I think, as far as the abstention goes, this is the second time board member Lamontaine's done that. And I think that it's not even necessarily because he has an interest in the applicant. It seems like he works in his other capacities, professionally with certain townships and municipalities. And he just doesn't, wants to be impartial and remain, avoid the appearance of impropriety. And so he just says, hey, I know where these are applying. I'm just going to kind of step back and let everyone else put a vote to it.
Again, that's perfectly reasonable. I think we can, split a hair about like when is it appropriate to abstain or not. But at the end of the day, if an individual on an administrative board feels that their decision can't be, objective, then it's better for that person to attempt to remain objective on their decisions moving forward. And I hope that other board members, if they're in a position where they have more knowledge than they should outside the scope of their reasoning for being on that board, it's better to be overly cautious than underly, I think. Right. So, yeah. But let's talk about the applicant itself. What was going on here?
So this one, I think, one of the board members brought up that there was, a caregiver as a supplemental applicant. And through these questions, we've learned that they're asking questions that to give them a better context of financials and just, generally with everyone. And it happened that certain explanations that were given raised a red flag appears to be for some of the board members regarding the numbers of harvests per plant and things like that maybe have led to believe that something else was going on there. So that was one thing, and then there was another supplemental applicant that had 2 undisclosed arrests for better or for worse. It was some 20 or so years ago, but it's still I think in this case the response to that deficiency was the issue.
Right.
So it wasn't necessarily that it was undisclosed; it was afterwards and the follow up with it.
Right, and again, there were several items discussed. One might have warranted more communication, but it wasn't the only issue with the application. I think it'd be easier to watch that discussion and think that it was only about the assumptions being made about caregiver conduct, but there were other issues as well, and then the denial itself was based on several issues, not just one thing. Mm-hmm. And again, Mike, we again the appeal process is pretty quick. I think 3 or 4 videos ago we did a whole conversation regarding like what that appeal process is going to look like, and I defer to that because it's going to end up being like a very long conversation. So apologies. I'm happy to try to point you in the right direction after the video as well. Just ping me if you have additional questions about it.
I was going to say too, as we're going over these, and we've mentioned it before, this is only a snapshot of what actually was reviewed by the board and discussed and prepared by Laura. So all we're working off of is what was said out loud and discussed amongst the members. So exactly. For all these other applications, we're not sure how much.
And we've said this. We've said this ad nauseum. There's probably information on this record that doesn't warrant conversation. That might be leading towards the decisions being made. Board members are going to be, perhaps emphasizing certain elements to perhaps influence the decisions of their other board members. But that doesn't mean there isn't other information in the reports that just don't, issue the decision to, discuss it. Mm-hmm. For example, we had I don't think we're going to talk about it, but one of the applications got approved 4-1. And the person who voted no didn't necessarily discuss why they were a no vote, but that doesn't mean there wasn't good reasoning for it. Mm-hmm. So, yeah. But,
so going back to Green Labs, though, I think there was a kind of a discussion between Laura and the board during this that was kind of worthy bringing up. Laura had clarified that the biggest mistakes certain applicants are making is with their juvenile offenses and traffic offenses. And so I think we can, take the time and maybe break those two down. I think as far as juvenile records, I know Laura maybe threw some attorneys under the bus saying, attorneys are systematically saying that they don't have to, disclose juvenile records or things that have been expunged. Right. I don't know that that's the case. I know that, from the beginning, we've always said that these need to be disclosed across the board.
I think it's very clear that if there was an arrest, the arrest needs to be disclosed regardless of if that arrest is currently sealed or expunged or from a juvenile account or anything like that. Mm-hmm. When it went specifically for traffic offenses.
And that's where it gets tricky because a lot of the times it's not an arrest. There's certain things that you can get ticketed for that rise to the level of a misdemeanor or certainly certain even traffic offenses can be felonies. So there's definitely, it doesn't click in the minds of everyone just that, I was arrested here. I was charged with this. So
just to be clear, no one's looking for a whole history of speeding tickets or parking violations. What they're looking for is if your moving offense, your traffic violation, ended up rising to the type of conduct that warranted criminal liability. So moving from the civil infraction category to the criminal conduct category. And the reasoning for that is because criminal history of any kind is required to be disclosed. So a moving violation, a speeding ticket, is a civil infraction. But, other traffic violations aren't just civil infractions. They amount into what usually starts as like a misdemeanor of some kind. So it's not the worst criminal violation, but it is still criminal in nature, and that is why it's required to be disclosed, because it's been made very clear your entire criminal history needs to be disclosed. So while traffic violations is a great category of where some of those things end up in one bucket and sometimes they cross the threshold into another bucket, you as the applicant or you as the supplemental applicant have a duty to report those things, because that's how the law is designed. And that they just wanted to emphasize that it's easy for applicants, and sometimes it's difficult to get this information, but it's easy for applicants to just assume, since it was traffic in nature, it doesn't require to be disclosed. Well, that's not in fact true. So it's the type of traffic violation that's important.
Mm-hmm. And I think too, the board members kind of focusing on that language that talks about any arrest, any charge, any indictment, any conviction. I think that things are definitely crystal clear now. Obviously, we're not sure when this applicant submitted their application. Perhaps it was in January or February when things were a little less clear.
Right.
Before the board or the department had updated Disclosure 7 and 7A SA with the criminal history. So there's, but I think certainly after this, at this point in the application process, if you were to not disclose something and then say you thought it didn't because, only one of these categories or one of these baskets had to be, I think that now it's pretty, they've made it very clear that that's not the case, and you need to make sure that you disclose any.
Which is not new information here. It's just being emphasized again. And again, when applicants finally make it to the agenda, it's not necessarily clear. Obviously, if they had watched the last 2 or 3 board meetings, they would have known this, but they might not have, they might have already issued responses to these questions prior to that. We don't really have an idea of the timeline of when these responses were received in regards to the decision being made. So let's kind of talk about a very interesting application. I think there might have been a bit of error being made by some of our board members. What was going on with the temporary operating provision?
Yeah, so for Ann Arbor Provisioning Center, it seemed like after this discussion about Green Labs, they went through and they said, okay, here's the next application. There wasn't really a discussion, to my knowledge. Somebody put a motion on there to approve them. It was approved 3-2. Once we went down to the next one, which was a grower application, one of the board members started bringing up the fact that it was a temporary operating provisioning center. It started going on about financials and so on and so forth. And Laura clarified that actually, the one before that was the provisioning center that the board member was talking about. So, obviously there was some signals being crossed,
right,
where they weren't sure in what order at least that first one was. But then,
and to the credit, I mean, we're all human, we all make mistakes. It was the same true parties of interest involved. And what a true party of interest means is it's the the people who end up being supplemental applicants who are required to make disclosures. So if you're looking at 2 different companies who would be 2 separate applicants, if I owned both those companies, I would be the true party of interest for both companies. So it's easy to assume, like when you're talking about the entity application, that the company that gets listed on the agenda, if it says Travis's LLC and I own that, and it says Travis's Grow, I'm still the same person making all the actual necessary disclosures. So just because one company, the assumption being made, it's perfectly reasonable if you think about how these applications are being reviewed, that the meat of the emphasis is on the true party of interest, especially for new companies, which I assume most of these would be. Maybe not in this particular case, but
yeah. So basically, there was obviously some confusion. There were 4 applications from the same true party of interest. The first one got approved 3-2. The next one got denied 3-2, and then the last 2 got denied 5-0. As I mentioned a little bit, the board members were discussing certain financials associated with his temporary operator. Don't want to get too much into that because we didn't see the whole picture. But there is definitely, in terms of consistency, objectively without any other context, this looks a little on the bad side, whereas, you have the same group, but it's not matching up. So, I think the thing was that they were trying to maybe revisit that decision. I know that one of the board members said, don't we owe it to the applicant to let them know,
right,
before step 2, before they do the whole build out of their property and have inspections, whether or not we're going to deny them or approve them.
Right. And again, just to emphasize, these were all step 1 conversations. So if even, and this kind of got emphasized as well, regardless of if the board member at issue here, perhaps got some signals crossed, a step one is only half of a complete application. So in step two, those concerns can be slightly addressed again. But speaking of step twos, obviously the step ones are where the heart of a lot of these conversations happen. We did finally get some more in-depth conversation about what these step two evaluations are going to look like. Mm-hmm. Let's start with applicant Iron Labs.
Mm-hmm. Oh yeah, and just to kind of back up for a second, there were 10 that they did, and only one of them got denied. So that was very, that was a lot, more significant chunk that got approved compared to the step ones. For Iron Labs, I think it was interesting to know, and obviously, we knew this was happening, but the board members for sure read your facility plan, technology, record keeping, all of the above, as they are supposed to, and the department does as well. But they expect you to know technology plan, who your third-party integrator is. They had questions about a fire cabinet and the Bureau of Fire Safety Inspection. So they definitely do their due diligence in reading the reports that Laura gives them. They're asking specific questions to make sure things are up to specification. So in terms of preparing your step two narratives, I think it's very important not to just skirt by and put down whatever. I think it's important knowing that they're going to read it thoroughly to make sure all your I's are dotted and T's are crossed.
And just like for the first few applicants that went through the step one evaluations, we're starting to see the first few applicants going through step two conversations. And what's going to happen here is they're going to have to be the ones to test the waters with the board again. And everyone who's working on step two projects that has the benefit of watching these conversations unfold will learn that insight, glean the tips and know-how to put better applications before Laura and the board that are going to perhaps emphasize the elements that are important to those decisions. Mm-hmm. So we did get one denied. Let's kind of focus on that, because this is truly the first step two that I'm aware of that was denied based on in part on step two issues. Or was that?
I believe there might have been one other one.
Was there?
And I think one might have gotten tabled. But this one did have a lot more step. I don't think there hasn't been one denied for a step two active facility.
Yeah. So what's happening now? Then I guess just to emphasize is if you are a lot of applicants, I'd say the vast majority of them submitted just their step one materials. If you're an applicant that submitted both step one and step two, it is one application, so it'll be reviewed as one application. So I was mistaken. I know Nick's our expert on the board here, so he knows the details better than I do. So when we're seeing denials, almost all of them have been step one denials. I was under the impression the one that got denied, that was a full application, had some step two issues as well.
I can't quite recall, but I'm pretty sure that it was just more of a step one question than with the actual facility. So, but for this one, step one, false info and moral and integrity.
So more
was
more
raised
of the same
by the board as a denial. It was again just criminal history and some financial issues that they may have flagged.
Yeah, so more of the same kind of no usual suspects here when it comes to board basing denials.
And then the other supplemental applicant renting commercial properties where they had acknowledged a caregiver was at least to me objectively, and again we don't know what also was contained in there, but objectively to me, I got to be honest, a 4,000 square foot building rented out to caregivers isn't really indicative of bad or good conduct. There could be a potential situation where you're renting it out to multiple caregivers, which is completely allowed under the looter. So you can't necessarily say, at least on the information that we have.
Especially knowing the city of Detroit. I mean, the city of Detroit effectively set up a process where if you wanted to engage in caregiver conduct and you didn't want to do that in your basements and garages, you had to do it in a very complicated municipal application. This was all before the MMFLA. And because of the costs and time sink associated with that, it just made sense for multiple caregivers to share the burden of running property or owning property. So a larger space allowed for more caregivers. As long as they're all in enclosed locked facilities and separate and not, putting all their plants in a big pile, that's allowed under the MMFLA. I'm sorry, the Medical Marijuana Act, the MMMA. And for a time that was allowed in the city of Detroit. So to base an assumption on the square footage, especially, it was no surprise that the state of Michigan was moving towards expanding its medical marijuana laws. It's been working on it since at least 2012, probably before that. So, it makes sense for people who want to take advantage of that to invest in property that might be more applicable for, a medical marijuana license. The same way several people are investing in property that might be more applicable for an adult use license. So to see just because of the fact that a caregiver is involved in this and the square footage is excessive for what one person might need, to glean in some, assumptions that, there's only one answer here and it's they're growing for the black market, seems to be adding so many assumptions of to base that denial on, that it's quite frankly, insulting to the applicant. I mean, if there's evidence of that, that should be in the record, and then you make your decision based on evidence. I mean, that's the whole point of the review process, and it's kind of frustrating to see that continue to be a discussion topic. It's one thing if there is evidence and you're basing your decision on that, then you should base your decision on that.
So, and like I said, to be fair, we're not sure what else was in that report that wasn't mentioned. So, we're only getting what was said there and our interpretation of it. So again, kind of defer to the board based on what was there, and the majority, prevailed on that. So
true. So to again, they're learning, they're testing the waters, and they're trying to figure out what their roles are, and that's going to be a process. And we're all human here. We're all doing this for the first time, and it's as frustrating as certain elements of this are. There are signs of hope and a bright future for this. So it's kind of a quick summary of how things are going down. The board did mention, Laura did mention some just overall updates. There were some comments and questions from board members to Laura. It's really the only opportunity they have to kind of communicate like that.
I was going to say, before we jump into that, can we talk about Green Skies? Because I thought that was a pretty interesting kind of teaching, just wanted to get it out there. So for Green Skies, there were 3 applications. This is another situation where there was a true party of interest, the same on all 3 applications. There was a bit of a discussion between the board about, seemed to be one person on the application. They seemed to be an elderly person that was 83 years old. There were some questions about whether they were a straw man owner or, somebody else, potentially a family member who there may be social media records about saying they're associated with this business actually running the company. Again, I think that might be getting a little bit too into the assumption land of things. All 3 applications ended up getting approved 4-1. But I just think that the way, and I think that the board needs to realize, and just all applicants, and I think that, not all groups might be doing this, but, right now people are applying that have the capital, that have the equity, that have the, knowledge. They're going to be inserting their team at some later point with all those managers and managerial employees, and as more members get brought on board. So just to assume that this one person who, of a certain age was going to not be running it and there weren't going to be people added later, I think is a misconception. I think that, step 1 never ends. So to look at this application and say, oh, this is one person, somebody else must be running it, I don't think is truly accurate of every situation.
And it's important to remember, if you're on our side of the fence here, going through this process is burdensome, time consuming, and you have no guarantee you're going to be licensed. So before you're in a position to hire employees and actually operate a facility, you need a core group of your team to submit application materials and have step 1s approved and step 2s approved. But that doesn't mean anyone's hired their trimmers and their receptionists, their staff to run these facilities. And some of those staff members, some of those employees are going to be in a category where they have to go through step 1 as well. So, maybe this person and other applicants are putting together applications so that they can get reviewed by the board, so they can get a license in their hands, so that they can tell someone who might want to work for them, yes, you can work for me. I actually have the ability to do it. But depending on how those people coming in want to work for that company, some of them have to go through step 1s too. So, it doesn't really matter if the guy was 84 or 104. If he wants to do this, who are you to say he can't? And if he does want to put his son in a position of management and his son is truly disqualified from step 1, well, guess what? He's not going to be allowed to be a manager. So it doesn't matter if his son thinks he's going to be. The step 1 is basically going to prevent him from doing that if what we believe what was stated on the record, that there's some disqualifying features there. Mm-hmm. So, if my dad, I might go on Facebook and say, my dad's company is my company, but that doesn't make it true either, right? So, and again, I don't want to talk too many details, but in general, we're starting to see some friction when decisions are being based in assumptions. I think they're getting better at that. It's not good to ever see it, but it's being called out by other board members. And if it happens, and it was a denial that was truly based on an assumption, there is an appeals process. So.
Yeah, and I think, it's the continued reporting requirements and constant monitoring and constant security surveillance of these facilities, I think should alleviate a lot of these problems. If this particular applicant did get licensed, or I mean they did, but if they were to try to have this arrangement happen that was maybe an assumption, there would be a good paper trail of that with signatures and camera footage and metric entries and things that maybe someone shouldn't have access to that they're controlling. So, the Lara and the department will either identify that as being a problem in the renewal application or during post-licensure investigation. So I think all of those maybe fears will sort themselves out because of how strict compliance and regulatory, rules that are set up in place. So
which we all have to remember, we don't have any of that happening right now. So we have a board, and this has changed. It happens at every level of this. There's gatekeeping that's happening because everyone resists change. There's gatekeeping in local municipalities, and maybe the township opts in, but the planning commission starts making decisions because they're not ready for change, and then it happens all the way up to the top levels, right? And once we have an industry, once people see the way Lara polices that industry, that I think we'll start seeing it easing up on this pre-disqualification kind of process. But until we get there, they want to start from a position of, the applicants that get through are going to be good applicants when it comes to following the law and complying with regulations.
They're still trying to find that baseline of where they want to set.
Right. And again, and the applicants that are pushing those boundaries, it's very unfair in some cases, especially when you have more information about the types of groups those people are and their desire to do this. And no one wants to see someone prevented from doing something they have a desire to do based on an unfair determination. But, we have to be reasonable about everyone's position in this process. It's Lara's job to implement the statute. It's the board's job to make decisions. And that's going to continue to happen. And we have no precedent right now. We're creating it for the first time. So we'll continue to watch as that whole process unfolds, and unfortunately it's like watching sausage be made. It's not necessarily going to be pretty, and they're going to kind of have some stumbles and some wins as they go. And it's important right now to remember, like, there's more change coming. If we pass a law in November, we're going to have a whole new set of considerations, processes, and change that people are going to have to face and deal with. But in the meantime, we'll continue to keep track of everything, watch how things go. So I think that's going to do it for us today. Thanks for joining us. I know we had some questions. If we weren't able to kind of address them while we were talking, like I said, we had a lot to discuss for the board meeting. We'll try to jump in the comments and respond to some of you directly. But for Travis Copenhaver,
Nicholas Galendez,
thanks for joining us today. We'll see you next week.